Can you lie in your recorded statement or your deposition? The answer to both of those questions is no. But before we get into that, let's talk about some of the similarities and differences between a deposition, which is something that you do when you're in litigation, and a recorded statement, which is typically something that's done at the outset of the case, usually, 1 or 2 days, maybe a week after an accident. So in a recorded statement, what's going to happen is that an insurance adjuster is going to call you, and they're going to ask you the who, what, when, where, what, and how questions. They're going to ask you what you saw, what happened to the cars, where were you going, what happened to your body, what kind of medical treatment have you had, things like that. Now, because these things are done pretty early on after an accident, it's not a very long conversation. Usually they're, 15, 20, maybe 30 minutes, and they're pretty quick. But you do have to be honest, because that may be used against you down the line if you've said something that's not truthful. Now, in a deposition, it's a little bit different. You're going to be with your attorney, and there's going to be a court reporter there. It might be videotaped, and an opposing attorney is going to ask you some of those same questions, but is going to do kind of a deeper dive on what has happened in the crash and what has happened to you as far as your symptoms and your medical treatment. Now, the similarity between an insurance recorded statement and a deposition is that you're obligated to provide information under penalty of perjury. And that just means that you have to tell the truth, because if you don't, there might be consequences. There might be criminal consequences if you don't tell the truth. So no, don't lie in your recorded statement. Don't lie in your deposition. Be truthful, be honest.